you have read the briefs, and as soon as I get to the appropriate one. We're ready to proceed.
Thank you. May it please the court, my name is Cedric Coben, and I represent the appellant MD, a juvenile in this case. This case undoubtedly is important to not only our office, I imagine it will be important to a lot of people, because this is, according to my research, the first of one of these type cases, and I guess what relates to this epidemic of heroin overdoses. To start with, because you're forced to present issues for review, this case can be complicated. And as I was thinking about oral argument, as I step back, it really boils down to a couple relatively simple issues. One, can a person be convicted or adjudicated delinquent under our present state of law when all of the state's evidence points to the juvenile provided something that assisted a buyer, in this case also the victim, in the purchase of an illegal substance, whether it be heroin or some other drug. Now, in this case, the MD was charged with manslaughter based on two separate felonies, one trafficking in heroin, which is my first issue, and the second felony was corrupted another with drugs. Now, in order to prove this case, the state had to prove that MD acted in complicity to trafficking in heroin. Now, if you look at the facts of the case, in the simplest terms, the state basically proved that the victim called the juvenile. The juvenile then in turn called Brandon Bartow, who was with another individual named Ty-Don Beaver. Ty-Don Beaver allegedly knew a drug dealer, and the state's evidence is actually sketchy on that point too, which I'll get to. They drove to an area outside what used to be Rolling Acres Mall, a club called the Ace of Spades. And based on the testimony of Brandon Bartow, they parked at the direction of Ty-Don Beaver. An individual walked up behind that car, and Mr. Bartow testified that someone walked up to the passenger side, and he observed the deceased person now hand something to this unknown individual. So there's no evidence in this case that the state ever presented that there was a drug dealer involved. There's speculation about drug dealers. The evidence speculates what was sold. The transcript reveals that Brandon testified during this encounter, he never saw anyone sell drugs. What he was doing, he testified he was sitting there playing with his phone. He looked up and he saw the victim reach from the back seat and hand an unidentified person something. Okay? Now, the evidence that the state presented at trial basically showed that MD, the juvenile in this case, provided information to the deceased, provided contact information, and then they all end up in this car, and allegedly some drugs were passed. Specifically, the state alleged that heroin was sold. This court is left to speculate about whether heroin was sold, aspirin was sold. We don't know. We just know that something transpired outside the Ace of Spades. Now back to my first issue. Now,
Excuse me for just a moment. I thought I asked whether or not you wish to have any time reserved for.
no, I do not want to reserve my time.
Okay, go right ahead.
Back to my first issue. There comes a point in any prosecution where you're not, you go beyond prosecuting cases and you're creating law. Now clearly the legislature sets those boundaries. The legislature has formed two separate crimes, one of possession, one of trafficking. The legislature, by setting those crimes, they set boundaries in possible prosecution. They've clearly set a standard where people who purchase drugs will be punished in a certain way, and people who sell drugs are being punished a certain way. Now, the state proceeded on a theory that the juvenile in this case, a complicity theory. All their evidence points that her sole contact was with the purchaser. And based on that, in my outline in my brief, why no such crime exists unless the state had evidence to prove that she assisted the seller. And for that reason, this court should reverse based on the first issue.
Now, the state has said that, I believe in its brief, that to assist the purchaser is to assist the seller.
That is-
Respond to that.
I want to say that's correct, but I hesitate because I believe in every sale, if you purchase, you're assisting the seller. But when the legislature certainly took that in mind, in a prostitution case, isn't the person buying it and he's assisted in but he's actually, charged and convicted of solicitation. So in any of those type of cases, in a violation of CPO, if the victim calls the defendant and the defendant goes over, she's in some respect, assisting him in violating the civil protection order, but we don't charge that person with violating the civil protection order. The legislature has made those choices. I think in the state's brief, they try to shy away from the fact that they're not, I think the words they're using, they're not proceeding on a theory of assisting the buyer. But the evidence, all their evidence at trial showed that the juvenile, if she did anything, she assisted the buyer. Then there's also the issue of the sufficiency of the evidence. One, I believe based on just the evidence that the state submitted, this court is left to speculate about what was sold, if anything.
Well, in the testimony, as I understand it, established, the calls that you referenced earlier, from the decedent to the juvenile to Brandon and so on, and they're getting to this point. There was no question but that the decedent was looking to purchase drugs. That, I think, was established by the text messages and the testimony of the officer. And so even though there was no explicit testimony regarding whether heroin changed hands in the car, wouldn't it be circumstantial evidence that once they returned from that encounter and she went to the bathroom and later, the needle was found and a spoon was found and she was dead, couldn't the jury reasonably infer that it was from heroin once it was found in her system?
Well, under the facts of this case, there's a little bit more to it. I believe you're absolutely correct. I do want to point out that Brandon testified that he was not actually looking when this whole exchange took place.
Correct.
Okay, that's the first thing I want to point out. As far as circumstantial evidence, I believe you're correct, but when you look at the case in its entirety, I believe that's incorrect. And let me explain it. Okay, you have this alleged sale. So if we assume that, for the sake of argument, that the victim did actually buy heroin, she could have bought other things. That's part of what I want to make clear. We don't know. What else we don't know? We don't know the actual cause of her death. And let me explain it. The medical examiner testified that the victim died of heroin use. Okay? Now, this purchase allegedly occurred like 5:30, 6:30, the day before she passed. Then she's last seen around 7:30 to 8:30 that night. The victim dies approximately 10 hours later from the time she's seen. She's last seen, I believe, one individual saw her coming into the home. And there's no testimony about anyone seeing her since. There's certainly circumstantial evidence that she could have went out and purchased other drugs. There's no casual connection between this alleged sale, 10, 12 hours prior to her death, and the same, if she purchased heroin, there's no evidence to connect to say she died from this purchase. And that's just assuming that she actually purchased heroin. Like you said, there's circumstantial evidence, but there's no evidence of what she purchased, if she purchased anything at all. And if we're talking about finding someone delinquent, that's a lot of speculation. I certainly don't think the state has to connect every single dot, but when you have a 10-hour difference in the time of this purchase, that is just circumstantial, and the death of the person, there has to be some other casual connection to prove proximate cause. Okay? The last thing is the second charge the juvenile with furnishing another with the drugs. Now, again, there's a point where we as lawyers, we can use words. We learned in law school to master interpreting words. But there's a limit to even the interpreting of furnishing, which is furnishing in the statute is very broad. I'll admit that much. Now, in this case, I think it's interesting to point out to what Judge Tito's wrote. The evidence clearly establishes that Amaro, who was the victim in this case, was new to the area and relied heavily on the jury, on the juvenile. Okay, we can twist those words and magically craft them and say, she furnished. But in reality, if you step back from the case, what did the state prove that the juvenile furnished? She furnished information. She furnished contact information. She did not furnish drugs. And again, if you want to stretch the words to the logical limit, but that's not what the statute says. The legislature says to furnish drugs to another. I think my point here is you reach to a certain limit where, and I give my example of driving someone to Walmart. Are you furnishing them, or are you furnishing a ride? I mean, we could interpret it in such a way, I'm furnishing that person with cigarettes, but no, I just drove them to Walmart. That's all I have, Your Honor. Thank you.
Thank you. Yes.
Your Honors, may it please the court, my name is Tabitha Stearns. I represent Appellee State of Ohio in this matter. Your Honors, the real issue in this case is, can the appellant be found delinquent of involuntary manslaughter based on either complicity to traffic in heroin or corrupting another with drugs? Now, on assignment of error 1, appellant raises the question to this court, can one be convicted of complicity to traffic in heroin if they only assisted the buyer? Now, the state contends that that contention on these facts of this case is totally misplaced before this court, because the appellant has interpreted the facts separately than the judge interpreted them, and separately than they were presented at court. I'm going to lay out the facts just a little to clarify them. Early in the morning, the decedent, Ms. Morrow, contacted the appellant and said, you know, I'm sick from drugs, can you help me get some drugs? She didn't know anybody in the area. Testimony established that. She didn't know any drug dealers. She was actually living with her cousin in this area to try to get clean from drugs. Now, the record reflects that appellant contacted people that she knew could hook her up with the seller, essentially agents of drug dealers that kind of connected sales. And appellant made sure, through all of her contacts in this case, that a drug sale happened. Now, I don't know what other conduct could possibly be assisting a seller, besides making sure a seller is at a certain location, a seller has a certain quantity of drugs, which in this case was $40 worth, which testimony established that was between 0.2 grams and 0.5 grams. She made sure she got part of that drug sale. The record reflects that she wanted a point, which is 1/10, either, well, it could be two things, Your Honors, either 1/10 of a gram of heroin or a needle full of heroin. And the detective testified that it is common that somebody gets a portion of the drugs when they hook up a drug sale. And in fact, the record reflects that through all of the text messages between appellant and Ms. Amaro, they never talked about a point. And viewing the evidence in the light most favorable to the state, one could infer that the only place that she would have made that agreement for the point would have been with the drug sellers. So she's
It's a
acting,
real stretch.
well, Your Honors, we have all
don't
of,
even know who the seller or sellers were.
well, she did know agents of these sellers, Your Honor, who, Tyden Beaver and Brandon Bartow, both worked to set up drug deals for this drug seller.
So they would be complicit.
Yes, Your Honor, they would both be complicit. I would say all of these people would be complicit in the trafficking of drugs. I mean, as far as all of these
So
people.
how far down the line does that go if you ask A if you say to A,
Mhm.
I'm interested in purchasing drugs, and A says, I don't really know who sells them, ask B. And then B says, I'm not really sure either, but ask C. And then C says, oh, I know,
Mhm.
it's D. Are B and C complicit?
Your Honor, that's possible, but that's not really what we have going on in this case. We have a much closer connection. We have A asking B, and B hooking up with agents of a drug seller, so it's more ABC than a longer line.
I'll be interested to, and you know, clearly the transcript will, I hope, provide a little more clarity.
Your Honor, the record reflects that Ms. Morrow contacted appellant, and then appellant contacted Bartow and Beaver, who made sure a drug sale took place. Well, they all three made sure a drug sale took place. The appellant made sure that there was transportation. She made sure they got, they picked up the decedent and they got to the drug sale. And like I said, she also made sure that the quality was right. And then she essentially got a commission from it, which apparently from the record, it looks like Ms. Morrow was not even aware of, because she texted Ms. Morrow at 7:30 at night and said, hey, you forgot to give me, kind of like my portion, the point.
Well, if she was the agent of the seller, why wouldn't she get from the seller?
Honestly, Your Honor, I'm not sure if there was just like a miscommunication or if there was so much going on that she just forgot. I'm not really sure. But I do know she was expecting part of this drug sale for herself.
For assisting the buyer?
It could be for assisting both, which would also be assisting the seller. And I think that we can have cases where you're solely assisting the buyer, Your Honors, but that's not really what's happening here. I think one of the examples that appellant gave in his oral argument was driving somebody to Walmart. I would say that's solely assisting the buyer. But we have somebody that's making sure they talk to the drug sellers and drug dealers and making sure that a drug sale happens. That's much more than solely riding with somebody in the car or driving them in the car. So this behavior goes well beyond solely assisting the buyer and also assisting the seller.
Well, if we just talk about assisting the buyer, and so I want you to just assume that that's all we have here.
Yes.
Does the conviction stand, or must it be reversed?
Your Honor, the conviction stands. I didn't address this in my brief because I do not believe that we have a justice assisting the buyer, which I did state in my brief that it does not fit the facts. But I actually have two cases from this Court of Appeals that say you can be a solely willing buyer of drugs. And State v. Ray, which is from this district, The citation is 1994 Westlaw 122313. Two undercover officers go to do their job and find drug sellers. And a guy walks up to them that has no drugs and no money, and he says, "What are you guys looking for?" And the officer says, "Well, I'm not looking for anything, but my friend is." So he takes them into a house and makes sure a drug sale happens. Now, he could say, "Well, I was just helping the buyer. You know, I didn't really assist the seller. I knew where drugs were sold, but I was just assisting the buyer," and he could escape liability. And this court said there was sufficient evidence that he quote-unquote sold crack cocaine because he was willing to facilitate drug purchases. In another case, State v. Silas, the citation is 104 Ohio Act 3rd 23, Your Honors. The assignment of error was the state sought to punish a willing buyer of cocaine under the statute directed at the seller of that substance. And this court said he agreed with another person to trafficking drugs, essentially buy drugs, and that was enough to violate the statute. Just being a willing buyer was enough to violate the statute. And Your Honors, I just want to point out that this issue of the procuring agent is not a new issue in the law. This is not necessarily a thing of first impression in Ohio. The 6th District was the case of first impression in this state, and the citation on that is 1978 Westlaw 214841. And the court in that case said, if we allow this procuring agent defense in Ohio, what that does is allows these go-between people who kind of work ipso facto for the buyer and the seller to escape liability. And the legislature wanted to kind of capture that behavior under the conspiracy statute mixed with the trafficking statute. We want to capture that behavior of acting to assist the buyer under the trafficking statute. So they didn't want to create a loophole where people could just say, just assisting the buyer and escape all liability.
And let me make sure I understand, you said you didn't cite these in your brief because of why?
Because, Your Honor, I don't feel that this appellant was solely assisting the buyer. I do feel that the facts do show that they were also assisting the seller. And, you know, they may have assisted the buyer, but they also assisted the seller, which violates the statute. So I think that this court could overrule that assignment of error just on the fact that appellant was assisting the seller and the buyer. Well, especially the seller. So, Your Honors, I've gone through the facts, but again, she was assisting the buyer, she was assisting the seller. Assisting the seller is what violates the statute. This court, if they were to hold that she was assisting the buyer, there is case law to support that conviction for trafficking too. So, Your Honors, I will ask you to overrule that assignment of error. The next 3 assignments of error are based on the sufficiency of the evidence. So assignment of error 2 is still on the trafficking conviction. And trafficking requires that somebody solicit the sale of drugs. Sufficient evidence was presented at trial to show that she did solicit the sale of drugs by contacting Mr. Bartow, making sure that a certain quantity, a certain quality was at the sale of drugs, and making sure that the drug dealer met them in a certain place, making sure that Ms. Amaro came with them to make sure a drug sale could happen. So Your Honors, it's basically the same, kind of the same facts as assignment of error 1. So she also, for the conspiracy part, she promoted and facilitated sale of drugs by making sure that that sale took place, that Ms. Amaro was able to buy drugs, and then a sale took place. So, Your Honors, we ask that you overrule assignment of error 2 based on the fact that appellant made sure a sale of drugs took place, and appellant hooked Ms. Amaro up with the drug sellers to buy drugs. In assignment of error 3, another sufficiency test, appellant asked this court to say that there was no proximate cause between the sale of drugs. Well, actually, appellant pretends that there was no sale of drugs, but so then there was definitely no proximate cause, according to appellant, from no sale of drugs to the later death. But Your Honors, that also isn't supported by the facts, because we do have testimony that from Mr. Bartow himself, who drove to the sale of drugs, he knew that the drug seller was contacted. He knew where to meet him. They go there. Also, Mr. Bartow knew that heroin was desired by Ms. Amaro. He said he did see money and something else exchange hands, which is circumstantial evidence of a sale of drugs. And then, on top of that, when they go back to Mr. Bartow's home, he says that Ms. Amaro calls appellant up to the bathroom, and then there was some commotion. And then he talks about being upset because he didn't want drugs being used in his mom's home. Apparently he lives with his mother. When he goes up to the bathroom after this commotion, on the sink he sees a spoon. And it's common knowledge that a spoon is generally used in heroin usage. A spoon is also, I believe, later found at the scene of the death. So then he takes Ms. Amaro and appellant to their respective homes. And then we have testimony from the people living at the home of Ms. Amaro that Mr. Bartow's vehicle drops Ms. Amaro off. We have testimony that Ms. Amaro comes in from the vehicle of Mr. Bartow. She says hello or good night or something like that to the people who live there. And then we have testimony that she goes upstairs and goes to bed. And we have testimony that that's the last time she's seen alive. Then we have testimony that she's found in that very same bedroom, dead, with heroin in her system. She's overdosed from heroin. So we can show every single place that she was, Your Honors, between the circumstantial evidence of that sale of drugs until she's found dead in that same bedroom that she was seen going into, apparently with drugs in her system, Your Honors, and dying of a heroin overdose. So there's a clear causal connection from the sale of drugs to her later death.
And the argument can't be made that she may have had more drugs at home which she used.
Your Honor, that argument can be made, but it wouldn't necessarily be reasonable because she said that she was sick from not having drugs, and all of her conversations with appellant talked about how she desperately needed drugs. If she had drugs, one would presume that she would use them to get unsick.
I don't know how much she bought, and I don't know how sick she was after taking the heroin that she purchased. My only question was, she went out and purchased it, but was there any inquiry into whether she also had some at home which could have been used?
Your Honors, I don't know if there was exactly testimony on point about finding or not finding heroin in the bedroom. So I can't really answer the question that there was or was not heroin in the bedroom, but I can tell you, I do not believe it is in the record that heroin was found in her bedroom. I believe there were just syringes, a belt, or something like that to act as a tourniquet.
Was there any testimony as to the amount purchased?
Yes,
And it was how much?
between 0.2 and 0.5 grams of heroin.
And was there any testimony that that amount of heroin would cause death?
I believe the medical examiner did testify to that.
And you have reached the end of your time.
Thank you, Your Honors. Your Honors, may I have just 1 second to ask for relief? Your Honors, as such, we ask that this court overrules the assignments of error and upholds conviction, or the delinquency.
Thank you.